practicing. Many times that it happens that when you go in compounding, Reserve Bank comes to it that the investment made ought to have been with prior permission of FIBB and it did not qualify for automatic loan. Reserve Bank tells you to go to FIBB post facto, get it approved by them and then go back to them to complete the compounding. One thing you must understand that compounding process has to be concluded within 180 days because that is prescribed under law. And in my experience, ever since compounding has started, there has not been a single case which has escaped notice of the Reserve Bank and has gone beyond 180 days. Usually after you submit your compounding application, within about 3 to 4 months, they give you a email or a letter saying that within this week you seek our appointment. They give you that latitude, which is unlike a notice from the income tax department that you appear on this day. No, they will give you a latitude that what suits you and then you can fix up the appointment conveniently. It has happened sometimes that that week is not convenient to the professional who is to appear before. And if the Reserve Bank is convinced, they will say, ask the professional which day is convenient to him. This latitude, where do you find? Because income tax fellows has come, otherwise will pass the order ex parte. Normally, Reserve Bank does not pass ex parte orders under compounding process. Of course, you know that the filing fee is 5,000 rupees, and that is towards the administrative cost. If they don't compound it, they feel that either they are exceeding 180 days or it is not compoundable. They will return your application and they will also return your fees. You don't have to ask for it again. And that's why in the latest circular they have said, okay, give us the details of your bank account. So they will deposit directly. Once again, at the cost of repeating because for compounding there is an application form, which is a very simple half-a-page form. Everything goes into the annexure which states the facts of the case. My suggestion and request to you is that in that statement, please be very polite. Don't use the word without prejudice against the Constitution of India and all that, because you are not fighting an appeal. You are going with folded hands that I have committed a mistake. Please permit me to rectify. It is cleansing your sins. Because nowadays, FEMA has been relaxed so much that most of the corporates, most of the people don't seek any professional advice and they go ahead and do what they like. And then come in trouble and come to us. Again, in your compounding process, at the time of the hearing also, don't quote any case laws. Compounding is based on facts, on a case-to-case basis. If you have an identical compounded case, that you can define. But don't say that the High Court said this and the tribunal said this. Please don't do it. If you don't like it, then that will go against you. When you as a professional appear before the compounding authority, you have to have a letter of authority. Letter of authority has to be on letterhead of the party whom you are representing. No stamp paper is required. They don't insist on any stamping fee. It has to be signed by the person who is authorized to sign such authority on the behalf of the client, and of course accepted by you. When the representative of the client appears with you at the compounding hearing, you first ask him about his visiting cards. You want to establish that the person appearing has authority. They make it very plain and simple. They ask you one form to be filled up. Who are you? Name, address, and designation. And then, if everything goes all right, within one hearing, the process is concluded, and about 10 days, you receive the order, either by fax or by speed post. And once it is compounded and you pay the fee prescribed within 15 days, you have to submit the proof of having paid to the Reserve Bank, and then the whole matter is over. Now, many clients would ask us, what do you expect will be the compounding fee? That is the penalties become. It is impossible to guess because it differs from officer to officer, because now more than one officers are involved in compounding process. Earlier it used to be only one, but now because of the increasing volume, there are many and their perceptions differ. So it is impossible, but only guesswork or an estimate you can give, it will be within one time, 100% of your amount involved, unlike 3 times in enforcement. But I think I have covered what I needed to, because I am very much conscious that I am addressing a professional gathering. So I was told not to make it too simple. If you have any questions, I will be delighted to answer. Thank you.
Friends, DILIP has told you everything about compounding process, how Reserve Bank evaluates your application. Now the floor is open for question answer, but only one request to all the participants. It is a tendency of the participants to look at the personality like DILIP Bhai, would like to solve all their questions here. So my request to all of you is to restrict your questions only to compounding process, Reserve Bank's view and related thereto. But do not raise any questions whether this would be a contravention or not. If possible, DILIP Bhai will answer it, but please limit your questions to the compounding process. Lastly, I forgot to mention in the introduction remark that DILIP Bhai is also an advisor to the International Tax Committee of the Chamber for last 20 years. With this, I open the floor for question and answer.
Sir, there is one case of a FGGPR. Can I refer? In 1997, the share application money was received. However, allotment was not done till 2011. FCGPR was also not filed.
Yeah, go ahead.
So, would that be a contravention? And would, second part is, should you approach Reserve Bank suo motu?
What do you think? I think you have answered your own question. Obviously, the regulation says once FDI is received, within 180 days you have to allot. If you have not allotted, you have not allotted. Now, you have not allotted, so you have contravened. Now you cannot refund it also. Period has lapsed because 2009 to 2011 you said.
Yes, 1997 to 2011.
97. So it's a good score. So for returning also you'll have to go to Reserve Bank. And for that compounding is a must. You see, you do not be aggressive. You have committed a mistake because the law is very clear on this. You did not read the law, it's not Reserve Bank's fault. You did not consult a professional, none of that was. So,
Sir, you said that in one of the cases the penalty was, fees was reduced from 127 crores to some few crores. So whenever we come across such things, is it advisable to go and meet the concerned person? Is there a possibility of requesting them for reducing the contravention fees or something like that, or just pay it and finish it?
no, once it is already passed, either you accept it or you don't accept it. Because there is no appeal. The only remedy is a writ petition. In that case of 127 crores, the company did not pay the penalty, so it lapsed. And then
It had gone under recognition.
they went into writ, but there was another contravention. For that, they made a further application in which they included the previous one. And by that time, the professionals represented it was accepted by the department. So it was
a lucky one.
Yeah, of course.
Sir, Sir, just to take ahead the point which on issue of shares. So because of this share controversy, we do see many company trying to hold on to the issuance of share because the price is yet to be discovered by the court and not by the company. So in such case, sir, what would be the advice? Does Reserve Bank of India grant extension beyond 180 days? So how should a taxpayer approach this? Because if you issue the shares at price X and this share controversy is hanging for the court to be decided. So practically, sir, one is yet to evolve a price. So how do one approach it?
No, no, no. Reserve Bank has no powers under the law to extend. So, I don't understand why there is a controversy over price. If you have gone into automatic route, you ought to know what the price should be.
So automatic route says suppose 100,
Yeah.
but as per income tax department it is 150.
Or you see one thing, there is no connection between Reserve Bank, FEMA and income tax. So, for income tax you cannot wait for allotment. You have to take a call. And this controversy about share and all is irrelevant because now the courts have said that share is not a part of income. It is all transfer pricing cases. So, Reserve Bank has nothing to do with it. So, you cannot wait to allot to determine a price. That you have to determine before getting in India the FDI. Then only the automatic route prevails. Otherwise, go to FIPD. So, have I made it that simple that there are no questions? Thank you.
In the Act, we have a provision for director appeal and tribunal also in FEMA.
Yes.
So what are they for if we cannot appeal the compounding?
That is against adjudication order. When the matter goes to enforcement, they issue a show cause notice. They allow you to reply to the show cause notice. And ultimately they don't agree, they levy a penalty. The penalty is levied through an adjudication order. That is appealable. Depending upon the volume, you first appeal to CIT appeal execution and then go to the tribunal in Delhi, then High Court and Supreme Court. Personal experience is not worth the trouble because you never get any relief till the High Court. The tribunal, FEMA tribunal in Delhi is a shame to democratic India. It is in such a lousy building. The judges may come, may not come. If they come, they may come at 11:30, 12. The day you are late, they will sit at 10:30. So it's a losing game completely. I have given up that practice because there is no point. You never win. But that, to answer your question, that is meant for the adjudication orders.
So if there is a disagreement, like if I am not agreeing on what RBI is saying on contravention, then the only option is to go under it, is it?
Either go under it or don't pay the compounding fee. So the
So
order
if I don't
lapses.
pay, what happens?
It lapses, and then the RBI will refer to enforcement. So, from your situation outside the cage of the lion, you go into the cage.
Sir, this adjudication order is appealable both the sides.
Yeah.
Likewise, if it is in the favor of the SSC,
Yeah,
so you file an appeal. Likewise, they can also.
There are instances where department has also gone to the tribunal. In fact, against the tribunal's order, department has also gone on revision.
Okay, same.
Both ways like income tax. Okay.
Sir, I have one question. Enforcement Directorate issues the Enforcement Directorate has issued the show cause notice. In the show cause notice, they narrated all the contraventions which the company has made. Do the company has a right to go for the compounding after issuing the show cause notice by the enforcement director?
So the provision is that once you are being investigated by any department of the government, not only enforcement but by any department, you cannot go in compounding. Now here your case is where they have issued a show cause notice and also narrated the contravention. Your doubts of compounding are closed. But let me give you an example where enforcement is making a preliminary inquiry it is not a show cause notice, then you are not under investigation. At that point you can go in compounding. In fact, they tell you to go in compounding. But once show cause is issued, you are under investigation.
Then we cannot go for compounding. Then we have to opt, then enforcement directorate will go for adjudication proceedings, they will proceed.
Sir, how many times in a lifetime one can go for compounding?
Every 3 years,
Every 3 years.
you will be habitual control. I would like such a client.
Sir, for allotment of shares, there could be several violations, right, starting from within 80 days, refund, etc., etc. So, should one file a separate compounding application for each of the offence, or combining all offence as regards to allotment and file single application?
Only single application once in 3 years.
But that application should cover all the
Everything.
irregularities
Everything.
as regards to allotment.
Yeah.
And it includes late allotment and filing forms, reporting intimation, and also refund, everything.
Everything.
Okay.
Whatever you can conceive, let Reserve Bank decide any part of it is not contravention. But you don't take a call.
Sir, you mentioned one instance about that wrong advice of the professional, where RBI questions about that professional advice and all those things. What is generally in such cases RBI's approach to the client as well as to the professional when such, let's say, that professional advice has worked reverse way? So what is RBI approach in such cases?
You see, in such a case, that professional who is wrongly advised is not before the RBI. He would not dare to be. So then, somebody like us goes there. And we say that at that time they did not have proper advice. RBI is very sympathetic to the client. If they find it genuine, that what they are doing is correct, they don't take any offense against the professional and they compound with a smaller penalty. It is usually happened like that.
One offense has been made because of the contravention, filing of the FDI at one point of time, and after say 9 months he has also been, without his notice, he has accepted such deposits, maybe terms as ECB kind of things. While I am compounding, I made only FDI declaration before the RBI. I was not knowing that, and RBI is also not knowing that this has been happened. So can I go for compounding thing, because the first proceeding is already concluded while I filed it, and within 9 months I got that ECB is also been contravened, I have not filed these things. So what is the remedy available with the client in that case?
Frankly, RBI will find out this. When you go for compounding, they go through your entire file because there is a separate file for each party. So it is very negligible chance that they have not noticed this. But if it has happened, then for next 3 years you cannot go for compounding.
So what is my fate in that case for ECB? Like suppose 9 months before that it has been concluded and ECBI also made a contravention. So there is 3 years I can't do anything. So what is the fate for me?
My suggestion would be wait for 3 years and then make the application, provided enforcement has not found you out. If they have found you out, best of luck.
And what kind of the fees normally they take? Like suppose there is a, I received a 2 crores rupees in form of the ECB, for example. Then what kind of the compounding they will do in terms of the 100% fees, or just broad idea about that, how the compounding they will do?
I think I mentioned that because it is impossible to guess. But
Out of your experience.
no, then if at all you are in compounding for this offense, first they will say go to the Reserve Bank, regularize it. Take a post facto LRF and then come back to us. If you have done that, that means the Reserve Bank is accepted. What they have accepted post facto, they could have accepted prior also. Only because of your lapse, it has not happened. Then there will be a minimum penalty.
Minimum penalty in terms one like.
I cannot guess, you have to go to an astrologer.
You suggested not to go for voluntary compounding. Now in a case, suppose there was a violation of first round of P investment. Now second round of P investment is going to happen. So I would prefer to go for compounding on the first round so that the second round I can comply with. So what would you suggest?
No, no, you see, in first round you have filed the forms required. You have not received the unique identification number.
No forms were filed.
Then file that form belatedly, immediately you will get a compounding notice. Make them to issue that notice to you. Don't go in it. Because once you go there, by a circular they have made it clear, okay, we will presume it is intentional and not technical. Then compounding fee may go up to 3 times. So create a situation whereby they will invite you.
Are they permit without a client compounding proceedings? In case client is not available and somehow like during that week they are not available.
Like next week.
Then the representative.
They don't hear the representative alone. It has to be somebody, I may not say even the peon, but somebody from the client has to be there. And they give you time, but if we are there in 180 days, no, they will return the application and say submit it again. So then 180 days period starts again.
So just while having the compounding fee, do RBI consider the role of authorized dealer? Because in many times there are mistakes which have happened from the client side, wherein even they have went to authorized dealer and they have not got the proper guidance. So if client documents that since it was not our intention, so does the fee gradually comes down? Because once we prove that authorized dealer was also not that much, because in most of the cases we have found this, that many times authorized dealer does not take proper action, they just do postman office job.
Yes, that's a very good question. In fact, I should have mentioned in my presentation. The earlier part of compounding process, when we said that we submitted to authorized dealer in time, because everything has to be routed to authorized dealer, but they delayed it. The immediate reaction of RBI was that you have to follow it. The professional like me, some seniors, we took up that case. We said, which clause of FEMA asked me to follow it up? There is no answer. And secondly, my argument was, who is an authorized dealer? Who has authorized him? I have not authorized him. You have authorized him, so he is your agent. And the principles of jurisprudence is that if you do anything through an agent, it is as good as none through the principal. So nowadays, there may be a smaller fee on you and a larger fee on the authorized dealer. They have started doing it. But after some of us doing what we did, yeah.
Thank you, DILIP, for answering all the questions. And thank you.